The Supreme Court chamber fell into a hushed silence as Justice Clarence Thomas leaned forward, his gaze fixed intently on Congresswoman Jasmine Crockett. Known for his years of silence during oral arguments, Thomas's sudden interest in questioning the freshman representative from Texas sent a ripple of surprise through the gallery. Camera shutters clicked rapidly as the 75-year-old justice cleared his throat. "Congresswoman Crockett," Thomas began, his deep voice reverberating through the marble chamber. "You've made some bold claims about constitutional interpretation in your amicus brief. Perhaps you could explain how your novel theory doesn't completely disregard 200 years of established precedent." The gallery tensed. Thomas's question, loaded with skepticism and designed to trap the newcomer, was clearly meant to put Crockett on the defensive. Legal experts exchanged glances. They had seen seasoned attorneys crumble under far less pointed questioning from the court's most conservative justice. Crockett stood motionless for just a moment, taking a slow, deliberate breath. Then a subtle smile formed at the corner of her mouth as she stepped toward the podium. The former criminal defense attorney and civil rights lawyer hadn't come unprepared. What happened next would not only stun Justice Thomas, but would soon become one of the most viral Supreme Court exchanges in recent memory. Don't forget to like this video and subscribe to our channel for more of these incredible political confrontations. Hit the notification bell so you never miss these powerful moments where history unfolds before your eyes. Jasmine Crockett had built a reputation as a quick-thinking legal powerhouse long before her election to Congress. At 42, the Harvard-educated lawyer had already made her mark as a civil rights attorney in Texas, where she had won several high-profile cases against powerful institutions. Her transition to politics had been meteoric, from the Texas House of Representatives to the U.S. Congress in just 2 years. Her appointment to the House Judiciary Committee had raised eyebrows, but her razor-sharp legal mind and prosecutors' instincts quickly silenced critics. "She's not someone you want to underestimate in a legal debate," a former law school colleague had told the Washington Post. "She prepares like no one else I've ever seen." That preparation had been on full display in her amicus brief to the Supreme Court in the case of Williams versus Federal Election Commission, a complex case about campaign finance regulations that had potential implications for corporate political spending. While not the lead attorney on the case, Crockett had submitted a brief that had drawn particular attention for its novel interpretation of the First Amendment as it related to corporate personhood and political speech. Across the chamber sat Justice Clarence Thomas, the longest-serving member of the current court and its most reliable conservative voice. Appointed by President George H.W. Bush in 1991, the 75-year-old Thomas had established himself as an originalist who believed the Constitution should be interpreted according to its original meaning. After years of silence during oral arguments, Thomas had become more vocal since the court began hearing cases remotely during the pandemic, and he had maintained that engagement upon return to the courtroom. His judicial philosophy stood in stark contrast to Crockett's more expansive view of constitutional interpretation. Where Thomas saw strict boundaries in the text, Crockett saw principles that could evolve with society. This fundamental difference made their confrontation not just a moment of legal debate, but a collision of deeply held worldviews about America's founding document. The stakes extended far beyond the chamber. Williams versus Federal Election Commission had the potential to either reinforce or significantly alter the court's controversial Citizens United ruling, which had opened the floodgates to corporate campaign spending. With midterm elections approaching, any decision would have immediate consequences for campaign finance across the country. For Crockett personally, this appearance represented a chance to establish herself as a constitutional thinker on a national stage. For Thomas, who had often seen his originalist philosophy challenged by progressive legal scholars. The exchange offered an opportunity to publicly refute what he viewed as a dangerous departure from the Constitution's original meaning. The gallery was packed with journalists, legal scholars, and political operatives, all aware that they were witnessing a rare direct confrontation between two figures representing fundamentally different approaches to America's legal framework. C-SPAN cameras captured every moment, ensuring that this exchange would be dissected in law schools and political forums across the nation. "Justice Thomas," Crockett began, her voice steady and confident. "I appreciate your question. Far from disregarding precedent, my analysis builds upon the foundation established in Justice Powell's concurrence in First National Bank of Boston versus Bellotti, where he recognized that the Constitution protects speech regardless of source, but also acknowledged the government's legitimate interest in preventing corruption." Thomas's eyebrows rose slightly. He hadn't expected such a specific and technically precise response, but he pressed on. "Congresswoman, Bellotti was decided nearly 50 years ago. Aren't you selectively choosing which precedents to follow while ignoring others, particularly Citizens United, which directly address these questions?" The tension in the chamber grew. Thomas rarely asked follow-up questions, signaling his unusual interest in challenging Crockett's position. Legal analysts in the gallery leaned forward, recognizing that Thomas was setting up what they call a jurisprudential trap, forcing Crockett to either contradict herself or concede a crucial point. Crockett paused, then spoke with measured precision. "Justice Thomas, I'm actually relying heavily on language from your own concurrence in Colorado Republican Federal Campaign Committee vs. FEC, where you yourself questioned whether corporations possess full First Amendment rights identical to individuals." She pulled out a document and read, "The framers of our Constitution certainly viewed corporations as entities separate from we the people, for whom the Constitution was established." Murmurs spread through the gallery. Crockett had just quoted Thomas's own words back to him, words that seemed at odds with his current judicial approach. Thomas's expression remained impassive, but his colleagues on the bench exchanged glances. "That concurrence addressed a different legal question," Thomas countered, his voice now carrying a slight edge. "You're taking my words out of context to support a position that would undermine corporate free speech protections this court has consistently upheld." "With respect, Justice Thomas," Crockett responded, "I'm applying the principle you articulated to its logical conclusion. If the framers viewed corporations as separate from we, the people, then shouldn't we examine with extra scrutiny when corporations claim rights specifically enumerated for the people?" Justice Elena Kagan leaned forward, clearly interested in the exchange. Justice Ketanji Brown Jackson scribbled notes. Even Chief Justice Roberts seemed engaged by the unexpectedly spirited back and forth. Thomas shifted his approach. "Let's be direct, Congresswoman. Your brief suggests a tiered approach to First Amendment protection based on whether the speaker is an individual or a corporation. Isn't that precisely the kind of speaker discrimination the First Amendment was designed to prevent?" The question was pointed, designed to force Crockett into a constitutional corner. Reporters frantically took notes, sensing the escalating tension. "Justice Thomas," Crockett replied, "the First Amendment's text doesn't mention corporations at all. Congress shall make no law. Abridging the freedom of speech tells us what Congress cannot do, but doesn't define who or what possesses that right inherently. That determination has always been made through interpretation, including by this court." She continued, picking up a copy of the Constitution from her materials. "When we look at the document as a whole, the people, human beings, are clearly centered. We the people, not we the people and corporations. The question isn't whether corporations have speech protection. Your jurisprudence has established they do. but rather the extent of that protection when balanced against the government's interest in preventing corruption. Thomas's eyes narrowed slightly. So you concede that corporations do have First Amendment protections? I acknowledge this court has recognized such protections, Crockett clarified carefully. What I question is whether those protections should be identical in every respect to those of natural persons, particularly when it comes to political expenditures that may corrupt the very democratic process the Constitution established. Justice Samuel Alito jumped in. Congresswoman, who decides what spending is corrupting? Isn't that inherently a political question that courts are ill-equipped to answer? Crockett turned toward Alito, but before she could respond, Thomas reclaimed the floor. The Congresswoman's brief suggests a framework where judges would have to evaluate which corporate speech is corrupting. That strikes me as exactly the kind of content-based regulation that our First Amendment jurisprudence has long prohibited. The exchange was growing more intense. Thomas rarely spoke this much during oral arguments, and his decision to repeatedly engage with Crockett signaled both his disagreement with her position and perhaps a recognition that she presented a formidable intellectual challenge. Crockett stood her ground. Justice Thomas, corruption isn't a content-based distinction. It's an effects-based concern that this court has recognized as compelling since Buckley v. Valeo. And as recently as McConnell v. FEC, the court acknowledged that Congress can take appropriate measures to prevent both the actual corruption threatened by large financial contributions and the appearance of corruption. Thomas leaned back slightly, his expression unreadable. The confrontation had moved beyond a simple exchange into a substantive debate about constitutional interpretation. Exactly the kind of intellectual sparring that rarely happened in the formal setting of the Supreme Court. Justice Thomas leaned forward again, his tone more pointed. Congresswoman Crockett, let's get to the heart of the matter. Your brief argues that the framers couldn't have intended to grant corporations full First Amendment protection because the corporate form as we know it today didn't exist in 1789. But couldn't the same argument apply to internet speech, broadcast media, or any modern form of communication? Should we limit First Amendment protections only to the technologies available in the 18th century? The question was a classic originalist trap, designed to force Crockett to either abandon her historical argument or take a position that would severely limit modern speech protections. Legal scholars in the gallery recognized it as Thomas's attempt to corner her with the inconsistency he perceived in her approach. Crockett took a sip of water, her composure unwavering. The room fell completely silent. Justice Thomas, she began. That's a thoughtful question that gets to the core of constitutional interpretation. The difference lies not in technologies, but in entities. The framers couldn't have foreseen Twitter or television, but they absolutely understood the distinction between natural, persons, and artificial legal constructs. She opened a weathered book. If I may, this is from James Madison's notes from the Constitutional Convention, where he expresses concern about the indefinite accumulation of property leading to an undue influence in the Republic. The framers were deeply concerned about concentrations of power corrupting democratic processes. A murmur went through the courtroom. Crockett had clearly come prepared with historical evidence that even Thomas, an originalist, would have to respect. The question isn't whether new technologies receive protection. Of course they do, as the means through which natural persons express themselves. The question is whether artificial entities created through state law should receive identical protection as the natural persons for whom the Constitution was expressly written. Thomas's expression shifted almost imperceptibly. He hadn't expected this level of originalist argument from the progressive Congresswoman. Before he could respond, she continued, "And if we're looking at original public meaning, Justice Thomas, Corporations in the founding era required explicit permission from state legislatures to exist and were limited to specific purposes. The framers would have found it astonishing that these entities could claim the same constitutional rights as citizens, particularly in influencing elections. Thomas adjusted his approach. But Congresswoman, even if we accept your historical framework, how do we square it with the court's precedent? Are you asking us to overturn decades of settled law? This was the moment Crockett had been waiting for. Justice Thomas, I'm actually asking the court to apply its own standards consistently. In your majority opinion in Dobbs, you wrote that when the court reconsiders precedent, it should look to whether the decision was egregiously wrong, had damaging consequences, and created concrete reliance interests. The gallery tensed. Crockett had just invoked Thomas's controversial Dobbs opinion, overturning Roe v. Wade, to challenge his position on corporate speech. By those same standards, Citizens United's extension of full First Amendment rights to corporations deserves reconsideration. The historical evidence suggests it was wrongly decided. The consequences for our democracy have been demonstrably harmful. And unlike in areas like reproductive rights, few concrete reliance interests would be disrupted by reconsidering the scope of corporate political speech. Justice Thomas's face remained impassive, but several of his colleagues, particularly Justices Kagan and Sotomayor, seemed to be suppressing smiles. Crockett had used Thomas's own judicial philosophy and standards for overturning precedent to challenge a decision he had supported. Congresswoman, Thomas said after a long pause, you've presented an interesting application of the court's precedent. But let me ask you directly, where in the Constitution's text do you find authorization for the government to treat corporate speech differently than individual speech, given that the First Amendment makes no such distinction? It was a direct challenge to her textual argument, Thomas's home territory as an originalist. The gallery held its breath, wondering if Crockett had finally been backed into a corner. She smiled slightly. Justice Thomas, I find that authorization in the same place you found the distinction between commercial speech and political speech in your opinion in Nike versus Caskey. Not in explicit text, but in the Constitution's structure, history, and underlying values. The Constitution never mentions commercial speech either. Yet the court has consistently recognized that it receives different protection. Thomas's eyes widened slightly. Crockett had just cited another of his own opinions to counter his argument. Before he could respond, she continued. And if we're being strictly textualist, Justice Thomas, the First Amendment says, Congress shall make no law abridging the freedom of speech. It doesn't specify whose speech. Yet this court has recognized many speech regulations that are constitutional, from fraud laws to defamation to true threats. The question has always been about balancing interests, not absolute prohibitions. The dynamic in the courtroom had shifted. What began as an attempt by Thomas to expose perceived weaknesses in Crockett's arguments had transformed into a showcase for her constitutional expertise and quick thinking. Even legal scholars who disagreed with her position had to acknowledge the skill with which she had met Thomas's challenges. One final question, Congresswoman, Thomas said, his voice betraying a hint of respect that hadn't been there initially. If we were to accept your framework, who decides where to draw the line? Would Congress have unlimited authority to restrict corporate political speech? Not at all, Justice Thomas, Crockett responded without hesitation. The court would retain its essential role in applying strict scrutiny to any restriction. My argument is simply that when it comes to artificial entities engaging in political spending that may corrupt the democratic process, the government's interest in preventing that corruption should be recognized as compelling, a position this court has taken repeatedly, from Buckley to McConnell. She concluded with a statement that resonated through the chamber. The Constitution was created to establish a government of, by, and for the people, not of, by, and for artificial legal entities. Recognizing that distinction doesn't undermine the First Amendment. It honors the document's fundamental purpose. As she finished, a rare silence filled the Supreme Court chamber. Justice Thomas leaned back, making a brief note on his pad. Whatever he had expected from this exchange, the Congresswoman's masterful navigation of constitutional theory, history, and precedent, including his own writings, had clearly surpassed it. Within hours of the oral arguments concluding, clips of the exchange between Justice Thomas and Congresswoman Crockett exploded across social media. Legal commentators from across the political spectrum weighed in on the rare moment when a Supreme Court justice engaged in such sustained questioning of a non-attorney appearing before the court. "What we witnessed was extraordinary," said constitutional scholar Lawrence Tribe on CNN. Justice Thomas, who for years rarely spoke during oral arguments, engaged in one of the most extensive questioning sessions in recent Supreme Court history. And Congresswoman Crockett met each question with remarkable constitutional fluency. Conservative legal analyst William Jacobson admitted on Fox News, "While I disagree with Crockett's conclusions, her command of constitutional law and precedent was impressive. She came prepared not just with her own arguments, but with intimate knowledge of Justice Thomas's own jurisprudence, which made for a compelling exchange." On social media, the hashtags #Crockett v. Thomas and Schamer Constitutional Showdown trended for days. Law students and professors dissected every moment of the exchange, with many law schools announcing they would use the transcript in their constitutional law courses as an example of high-level legal argumentation. For Jasmine Crockett, the aftermath was transformative. Once known primarily as a freshman representative, still finding her footing in Washington, she was suddenly being discussed as one of the Democratic Party's most effective constitutional voices. Interview requests flooded her office, and several prominent law schools invited her to deliver guest lectures on constitutional interpretation. What Congresswoman Crockett demonstrated wasn't just legal knowledge, but strategic thinking, noted former Solicitor General Neil Katyal on MSNBC. She anticipated Justice Thomas's originalist approach and came armed with historical evidence and precedents that spoke directly to his judicial philosophy. That's the kind of preparation that even veteran Supreme Court advocates sometimes miss. Conservative media took a different approach, with some outlets characterizing the exchange as disrespectful to the court's most senior justice. "There's a certain decorum expected before the Supreme Court," argued Judge Jeanine Pirro on Fox News. Crockett may have been technically proficient, but throwing a justice's words back at him crosses a line. This criticism only seemed to enhance Crockett's standing among progressives, who celebrated her willingness to directly challenge one of the court's most conservative members. For too long, Thomas's originalism has gone unchallenged in that chamber, tweeted prominent legal activist Ellie Meistel. Crockett showed that progressives can fight on that historical and textual terrain and win. Perhaps the most significant reaction came from the legal community itself. The American Bar Association Journal ran a cover story titled, "The Crockett Method: Preparation Meets Opportunity at SCOTUS," analyzing how her approach to the exchange could serve as a model for future advocates. Law professors reported that students were suddenly showing renewed interest in originalist arguments and historical research, tools traditionally associated with conservative legal thinking, as a way to advance progressive causes. For Justice Thomas, the exchange also had unexpected consequences. While he maintained his characteristic public silence about court matters, sources close to the justice suggested he had been genuinely surprised by Crockett's command of his own jurisprudence. At subsequent oral arguments, court watchers noted that Thomas seemed more engaged, asking questions that probed inconsistencies in advocates' positions, regardless of their ideological alignment. The substance of the exchange also sparked renewed debate about corporate personhood and campaign finance. Legal scholars published a flurry of articles reassessing the historical evidence regarding the founders' views on corporations, with several prominent originalist scholars acknowledging that the historical record was more complex than often presented. What's fascinating about this moment, explained constitutional historian Mary Sarah Bilder, is that it may have opened up space for a more nuanced originalist conversation about corporate rights. If both progressives and conservatives are now digging into the same historical materials, we might actually develop a more accurate understanding of the founding era's approach to these questions. 3 weeks after the oral arguments, the court requested supplemental briefing specifically addressing the historical evidence regarding corporate rights in the founding era. A move many interpreted as evidence that Crockett's arguments had made an impression on at least some of the justices. When the court's opinion in Williams v. Federal Election Commission was finally issued 4 months later, legal observers noted that while the 6-3 decision largely maintained the status quo on campaign finance, Chief Justice Roberts' majority opinion included several paragraphs acknowledging the historical evidence that corporations were viewed differently than natural persons in the founding era. Justice Thomas, writing separately in concurrence, specifically addressed the historical materials Crockett had presented, arguing that while informative, they didn't undermine the court's precedents on corporate speech. For Crockett personally, the experience reinforced her commitment to constitutional advocacy. In a speech at her alma mater, Harvard Law School, she reflected on the exchange. The Constitution doesn't belong to any ideology or party. It belongs to the American people, and its meaning is enriched when we engage deeply with its text, history, and values, especially when we disagree about what those mean. The exchange also elevated public understanding of complex constitutional issues. Law professor Zephyr Teachout noted, "For a brief moment, millions of Americans were engaged with sophisticated constitutional arguments about corporate personhood, originalism, and precedent. That kind of civic education is invaluable, regardless of where one stands on the issues." Perhaps most importantly, the Crockett-Thomas exchange demonstrated that substantive, good-faith constitutional debate remains possible even in a polarized era. What we witnessed wasn't just legal theater, wrote New York Times columnist David Brooks. It was two people with fundamentally different constitutional visions engaging seriously with each other's ideas. In today's political climate, that's something to celebrate. For Congresswoman Jasmine Crockett, what began as a challenging interrogation by the Supreme Court's most senior justice became a defining moment in her political career, one that established her as a constitutional thinker capable of going toe-to-toe with the court's intellectual heavyweights. And for Justice Thomas, the exchange served as a reminder that constitutional interpretation remains a living, evolving conversation, with new voices continuously emerging to challenge even the most established judicial philosophies. If you enjoyed this breakdown of the historic exchange between Justice Thomas and Congresswoman Crockett, please hit that like button and subscribe to our channel. We bring you in-depth analysis of the most important constitutional moments happening in America today. Don't forget to hit the notification bell so you'll be the first to know when we post new content about the Supreme Court, Congress, and the ongoing battle over America's founding principles.